Thank you for coming to our seminar about the new country guidance case on Sri Lanka. My name is Alistair Mackenzie. I'm leading counsel for both the appellants in this case, Mr. KK and Ms. RS. Can we move the slides on, please? Joining me to tell you, I should say, about our case is my Doughty Street colleague, Antonia Benfield, who was junior counsel for Mr. KK. And after we've spoken for a bit, we'll have time for questions, and joining us for that part of the seminar, at their own request, I should say, not because the barristers have shoved the solicitors off into a back seat again, will be Aaron Gananathan of Bernberg Pierce, who was the solicitor for KK, and Laura Smith, who was solicitor for RS and is from the JCWI, of course. For any of you who haven't attended one of our webinars before, you'll notice that your mics are muted and your videos are off. That's just a presetting to avoid interference and to save bandwidth. Please do feel free to ask questions. Please use the Q&A function at the bottom of your screens. We ask that you use that rather than the raise hand function. And the panelists will try and deal with as many questions as we have time for. If we don't have time to answer your question, please feel free to email us or our clerks after the webinar, and one of us will get back to you. We're recording this session, of course, so a copy of this and of the slides, the PowerPoints, will be available for you to look at, and for any of your colleagues who are unable to attend this afternoon. Next slide, please. So a little bit of context is necessary to understand what the issues are in KK and RS, and to see how and why the tribunal gave the guidance that it did. So up to the immediate aftermath of the Sri Lankan Civil War, we had the case of TK in late 2009, and that was following on from the earlier case of LP in 2007. LP decided, of course, during the Civil War. And the focus at that time was understood to be on current or former members of the LTTE or supporters of the LTTE, and the government of Sri Lanka's determination to track those people down and punish them. Next slide, please. So in 2013, we then moved on to GJ, and in that case, the government's focus of interest is found to have shifted to the Tamil diaspora. And whilst it remained the case in the tribunal's view that the government's overwhelming concern was to ensure that the internal armed conflict never occurs, the internal opposition, overt support for the LTTE or for anything resembling the LTTE's aims and objectives had basically entirely evaporated. And the primary locus of separatist activity, so for any kind of idea that there ought to be a separate Tamil state or even a significant degree of devolution or autonomy for Tamils to decide their own affairs in Sri Lanka, had shifted overseas in the tribunal's assessment, and it had particularly moved to the diaspora communities in Europe and North America, and to some extent Australia. And the tribunal said at paragraph 311 of GJ that the government's concern now is not with past membership or sympathy with the LTTE, but with whether a person is a destabilizing threat in post-conflict Sri Lanka. And those two things apparently, in the tribunal's view, were largely unconnected. Next slide, please. So it gave guidance to the effect that individuals who are or perceived to be a threat to the integrity of Sri Lanka as a single state because they have or are perceived to have a significant role in relation to post-conflict Tamil separatism and diaspora, and or a renewal of hostilities within Sri Lanka, those are the people considered to be at risk. What it didn't do, unfortunately, the tribunal in GJ, is explain in clear terms who would fall into that category. And to the extent that it did explain at least aspects of that question, it didn't include those answers in the actual country guidance set out in the headnote to the judgment. Next slide, please. What it said was simply that who was at risk was a question of fact in each case, dependent on any diaspora activities carried out by an individual. Now, you might very well feel that that's a bit of a dereliction of duty, because, you know, of course, the assessment of risk is a question of fact in each case. Obviously, it is. The whole point of country guidance is, at the very least, to guide decision makers as to what they ought to be looking at in deciding who, in practice, is at risk. It went on at paragraph 338 to use the phrase committed Tamil activists, who the government saw in the tribunal's assessment as a destabilizing threat to the state. But unfortunately, it didn't include that phrase in the headnote. And it went on to say at paragraph 351 that people who've merely attended one or even several demonstrations would not be at risk of persecution, with the implication, albeit, as I say, not adequately spelt out or included in the headnote, that the issue in most cases was whether a person's activism goes beyond that. And it did accept, but again, didn't include in the country guidance itself, that the government had an extensive network of informers in the diaspora, enabling it to identify who's active against the regime, and also that it interviewed people about their activities before allowing them to return, particularly if they were applying for an emergency travel document or replacement passport. And either way, it accepted that they would be most likely to know about anybody's activities in the UK by the time they return. But there are a number of omissions and uncertainties. Next slide, please. So first of all, where is the boundary to be drawn between those who are at risk and those who aren't? Is it simply a question of the number of demonstrations that you've attended? If that is the case, well, how many is enough? Is it 10, 20 or 30? Over what sort of period? Is 20 demonstrations over a period of 5 years more or less significant than, say, 10 demonstrations over the course of 1 year? What about activities other than attending demonstrations? And obviously, anybody who's ever participated in any form of politics, never mind Tamil activism, knows that demonstrations aren't the only thing you do. They're not even necessarily the main thing you do. But how does a decision maker assess the relevance of leafleting, attending meetings, fundraising, lobbying your MP, recruiting other people, participating in social activities or cultural activities linked to a political movement? GJ is almost entirely silent on that. Are there other factors relevant to the authorities' perception, such as your past personal links or your family's links to the LTTE? When GJ was appealed to the Court of Appeal by two of the appellants in that case, MP and NT, the Court of Appeal seemed to suggest that that was the case. And indeed, it's notable that the only appellant who actually won in GJ, which was the first appellant, Mr. GJ himself, won in part expressly on the basis that he was a former member of the LTT's finance wing, and indeed his sister had been Prabhakaran's, the LTT leader's, personal physician. But that didn't form part of the guidance given. And obviously, if your lead appellant succeeds on a basis different to the guidance you've just given, then perhaps there's something wrong with that guidance. And obviously, it also, as anybody who's dealt with these cases knows, didn't take very long before a lot of our FTT judges, with the active encouragement, it must be said, of the Home Office, found other ways to find that people are not at risk. So first of all, it's often suggested that people's activities would not be known to the authorities. That's in spite of the fact that GJ makes very clear that they would. So the problem is that that didn't appear in the guidance itself, indicating that the Home Office and at least some judges found it too onerous to read the judgment beyond the headnote. Secondly, it was suggested that only high-profile people at risk. Sometimes that's expressed as being that only people with a specific role in the opposition are at risk. Again, that's not what the tribunal said, but the vagueness of what it did say meant that it was open to that criticism. Thirdly, it was found often in many cases that it's relevant to consider people's motivation. So although it's accepted that the authorities will primarily have regard to your public activities, it's also assumed that they would want to consider whether you're undertaking those activities out of genuine commitment, and also that they've got some magical way of finding out what's inside your head other than torturing you. And fourthly, HJRN points, whether people want to continue to be politically active on return. That's simply not dealt with in GJ, and it's often ignored by decision makers. Now, despite all those flaws, that guidance had survived for some 7 years up to the point of the hearings in KK and RS, which were in September last year. And they'd survived 2 changes of government in Sri Lanka. First of all, the defeat of Mahinda Rajapaksa in the 2015 presidential elections, which did at one point, at least in some people's view, seem to be a positive development for human rights in Sri Lanka. And then the return of the Rajapaksa family to power with the election of Gotabaya Rajapaksa, Mahinda's brother, in the 2019 presidential elections, followed by a heavy victory for their party in the 2020 parliamentary elections. Next slide, please. So our position in KK and RS was basically that the GJ guidance needed clarifying to address some of these missing points, but it also needed broadening so that it included a greater number of people. And the Secretary of State's position was very much either that GJ was correct and didn't need changing, or in effect that it needed narrowing slightly. And both those points were advanced simultaneously without necessarily dealing with the apparent tension between them. And although the tribunal doesn't go quite as far as we would have liked it to, we basically said that anyone with more than very minimal involvement in Tamil activism was at risk. It certainly ends up at a point far closer to ours than the Secretary of State's. And as Antonio will explain in a few moments, it did provide very helpful clarification of a number of things that had previously been unclear. And it did broaden, I think it's fairly clear, the categories of person at risk. Before we get on to the specifics, I just wanted to say a word or two about how we went about the case and about our tactics. Next slide, please. So first of all, it was important to get into the minds of the UT, the Upper Tribunal, what sort of regime they're dealing with. There's obviously an assumption, which isn't limited to Sri Lankan cases, that persecutory regimes and their agents on the ground, as it were, are basically reasonable people. You know, they may be homicidal maniacs or even genocidal maniacs, but they're basically reasonable homicidal maniacs. This sort of affects the assessment of cases in the sense that, for example, to sort of make that more concrete with reference to the facts in Sri Lankan cases, it's often assumed, I think, by decision makers that the government of Sri Lanka wouldn't mind people publicly calling for the president to be arrested as a war criminal as long as they didn't really mean it. Or it's assumed that they'd only be interested in persecuting people who could, objectively speaking, on an assessment by the tribunal itself, be regarded as a threat to the state, rather than on the slightly more paranoid basis that the government might be, in reality, viewing them. So that often seems to involve a decision maker rather implausibly placing themselves in the shoes of a politician or a police officer from a persecutory regime and saying, well, you know, what would I do if I were them? Or, you know, what would the reasonable torturer on the Clapham omnibus do? I mean, it's never quite articulated that way, but that seems to be the underlying assumption in many cases. So it was very important, we felt, to talk about the mindset and the political priorities of the Rajapaksa regime. So to identify it as an authoritarian regime made up of Sinhalese / Buddhist chauvinists or racists, if you want to be less polite, who, number one, have a deep-seated ideological objection to the idea that the island of Sri Lanka might be divided or that Tamils might have any valid claim at all to occupy any part of the island. Secondly, they have a genuine and of course to some extent understandable concern not to allow a debilitating and bloody and expensive civil war or campaign of violence against the civilian population to start again. Thirdly, they gain political advantage from talking up the threat from the LTTE. And fourthly, they take a very wide view of what constitutes separatist activity, partly, although not only, because many of the prominent members of the government, individuals in the government, including Gotabaya himself, have been credibly accused of being war criminals themselves. So they've got a personal as well as institutional incentive to regard, for example, human rights activism as unacceptable forms of opposition. And the Upper Tribunal does broadly accept that. In the first paragraph of the headnote in KKNRS, it says, the current government of Sri Lanka is an authoritarian regime whose core focus is to prevent any resurgence of a separatist movement within Sri Lanka, which has as its ultimate goal the establishment of Tamil independent Tamil state, of course. And it regarded as particularly helpful an article written by Gotabaya Rajapaksa in a journal linked to the US military in 2014, in which he'd set out very clearly his view that various Tamil organizations were basically LTT fronts, which required to be suppressed. And all of that's obviously relevant, precisely because there's a lack of specific evidence as to the behavior of the government. First of all, obviously the current government had only been in power for less than a year, by the date of the hearing, and most of that had been during the pandemic. So there was essentially no evidence of people being returned forcibly since it had come to power, and very little evidence of how it might behave in more normal circumstances. And secondly, even in normal times, it's difficult to know exactly what, for example, appears on government databases or what criteria are used by officials on a case-by-case basis in deciding who to arrest and who to simply keep under observation. So again, one needs to deduce that kind of thing from first principles. Next slide, please. Secondly, it was important to us to ensure that the tribunal understood the nature of the Tamil opposition. So we had evidence about the TGTE. I think we've gone a bit too far ahead there. Yeah, back one, please. Sorry, no, that's correct. That's correct. Thank you very much. Yeah, so the need to understand the nature of the Tamil opposition. So we had evidence about the TGT, the Transnational Government Tamil, which for those of you who are not familiar is government in exile, basically set up in 2010 by people, many of whom did in fact have close links to the LTTE before the end of the war. TGT, now the main Tamil opposition organisation in the UK. We also had evidence about groups such as Tamil Solidarity, which is a more sort of left-leaning organisation to which Ms. RS and her husband were linked, and other Tamil groups operating in the UK. And several of those had been deprescribed by the previous regime before 2019, but in fact were quite helpfully, from our perspective at least, re-prescribed between the dates of the hearings and the date of the judgment. And obviously that supported our argument that A, the direction of travel was to get worse, and B, that there wasn't really much of an objective distinction between prescribed and non-prescribed organisations, and that whether a group was prescribed or not in Sri Lankan domestic law was a slightly arbitrary question, depending very much on the government's internal priorities and what it wanted to say, either domestically or to an international audience. And the tribunal reaches some helpful findings on that. And again, if you look at the headnote, you can see that it accepts that organisations which are prescribed under Sri Lankan domestic law, including the TGTE, are regarded with particular hostility, and that activism for groups like that is called a relatively significant risk factor. But other separatist groups which aren't prescribed, such as Tamil Solidarity, are also still regarded with hostility. So domestic prescription makes things worse, but it doesn't necessarily mean that you're not at risk just because your particular organisation hasn't been prescribed, which is basically what the Secretary of State was trying to say. Thirdly, it was quite important to us to avoid a battle over the credentials of the experts. Obviously, it's quite often that in these cases, the area of dispute seems to be over the experts, precisely because the Secretary of State so rarely calls expert evidence, and almost never does in ordinary FTT cases, of course. So it's only the appellant who instructs experts, let alone calls them to give oral evidence, and the Secretary of State basically regards her role as being to pick holes in their evidence. Not just to pick holes in what they say, but also sometimes to pick holes in their entitlement to say it at all. And just to go off at a slight tangent, if you don't mind, I mean, the new plan for immigration, which Priti Patel has put out this year, includes this idea from the Home Office of setting up some sort of panel of pre-approved experts who can be instructed in these cases, which is obviously an insane idea for all sorts of reasons. But the only basis on which you might possibly think that it was even remotely a valid proposal is because you think experts are basically for other people to call. And because you never instruct experts of your own, and you regard the experts who do get called as somehow being illegitimately favourable to appellants. And obviously the answer, if you don't like the appellant's experts, is to instruct your own, if you can find any who support you. So in this case, we sought to avoid that. And we proposed to the Secretary of State that the experts should be instructed on a joint basis. And the Secretary of State did agree to that. And that was, I think it's fair to say, a problematic thing in a lot of ways, including the need to consult the other side at every stage. But I think it probably on balance did have a lot of beneficial effects, including the fact that once the experts had produced reports supporting our case and undermining the Secretary of State's, as indeed we thought they were likely to do, the Secretary of State basically had an uphill battle to prove her case and to disprove ours, because she couldn't, and in any event she didn't really try to, launch any significant or sustained attack on their credibility as experts. And obviously that also meant that it was a very lengthy and time-consuming process of exchanging questions and getting the experts to provide supplementary reports before the hearing. The advantage, of course, was that they did provide very comprehensive written evidence and oral evidence was kept to a minimum. And in the end, all of them were largely accepted by the upper tribunal, with the exception perhaps of Professor Gunaran, some of his evidence about whether people would be forced to become informers was not accepted. And then finally, from me, we also felt it was very important to keep a careful eye on the appellants, because they sometimes, I think, get lost in CG cases. Both Mr. KK and Ms. RS, and indeed RS's husband, Mr. ST, were people who'd failed under the GJ test. It wasn't entirely clear that the extent of their activism had been fully understood or evidenced, but they had failed under GJ. So their level of activity for the TGTE and or for Tamil Solidarity provides you a kind of useful yardstick in some ways for how the guidance has changed and for what sort of activity is now regarded as relevant. So it's worth looking very carefully at the evidence of their facts. Although I'm not saying, in fact, it's very far from being the case that only people with that level of activity are likely to succeed. It seems to me that they're well within the category of people who are likely to succeed under the country guidance, and people with significantly less levels of activity are likely to succeed as well. So that's me for the moment, at least. I'm going to hand you over now to Antonia, who's going to go into the judgment in a bit more detail. Thank you.
Thank you, Alistair. So the upper tribunal in KKNRS was considering the risk category in GJ of individuals who are or are perceived to have a significant role in post-conflict Tamil separatism. And although the judgment makes some observations in relation to the other risk categories, in particular the maintenance of the category in relation to the stop list, the primary focus was on significant role in Tamil separatism. And the tribunal considered that that remains the appropriate touchstone, as they termed it, for the assessment of risk. The tribunal noted that continues to accurately reflect, on the one hand, that there is a degree of discernment on the part of the government of Sri Lanka as to who it perceives as constituting a threat to the integrity of Sri Lanka, but at the same time allowing for a fact-sensitive assessment to ensure effective protection under the Refugee Convention. Before coming to how the significant role was kind of assessed, or the framework that the tribunal puts forward, it's useful to note what the tribunal said it did not constitute. And in a sense, the points at the second bullet point, I think, will be familiar to all of us representing Tamil asylum seekers, really is what is said by presenting officers in the vast majority of cases to suggest that an individual does not have a significant role. So useful just to pause for a moment to see what the upper tribunal said about that. So firstly, it said that a significant role should not and was never intended to require a person to demonstrate that they had a formal role in an organisation. They also said that the fact that a person is not a member of a particular organisation doesn't preclude them having a profile sufficient to disclose risk on return. And a person doesn't need to show that their role is high profile or prominent in the sense of a position of leadership or substantial media exposure or organisational duties, and noted that applying a threshold of that nature would be inconsistent with the lower standard of proof applicable in asylum claims. Can I have the next slide, please? So the tribunal adopted the phrase of one of the experts, Dr. Nadaraja, that the assessment of risk is an indicator-based approach. And really that isn't a substantial change from GJ and others that said it was a fact-sensitive assessment of the nature and extent of activities carried out, but just building upon that, looking at indicators of risk. The tribunal noted that the government of Sri Lanka shouldn't be regarded as exercising no meaningful filter as to who is of sufficient adverse interest to justify detention. But the assessment of indicators has to be viewed in the light of the government of Sri Lanka's objective to identify those who are a threat, actual or perceived, to the integrity of Sri Lanka by reason of their committed activism in pursuit of a separate state. So what we have from the tribunal is a 6-point list of what are described as non-exhaustive elements, but which are to form a cumulative assessment after careful fact-finding. So the first is the nature of any particular organisation on behalf of whom a person has been active. The second is the type of activities undertaken, and we'll come in a moment to look at those first 2 points in a bit more detail. Third is the extent of any activities. So the tribunal noted that brief attendance at a single demonstration, even if known, was unlikely to be capable of establishing sufficient profile for a person to be at risk on return, but also noted that a few attendances could be capable of attracting greater significance if, for example, a person was speaking publicly at them. The fourth is the duration of activities, and the tribunal noted obvious logical point that the longer the relevant participation, the greater the possibility that the government of Sri Lanka may consider an individual is committed to separatism. And at this stage, at the analysis, and it's paragraph 494 of the judgment, the tribunal accepted that motivation for attendance was not relevant. So why an individual is involved in activities, in that the government of Sri Lanka, as the tribunal put it, will have little or no inclination to inquire about an individual's good faith or lack thereof. They did, however, note at that stage that the genuineness of belief in separatism and in activities is, of course, relevant to the application of HJ Iran principles, which we'll come to at the end. So then the fifth factor is an individual's history in Sri Lanka. And the tribunal considered it was a matter of logic that actual or perceived LTT links would be deemed relevant by the regime. It noted that relevance, of course, will depend on the facts of the case, and it won't, save for in exceptional circumstances, be determinative. And then finally, so number 6, familial connections. The tribunal states that relative links to either the LTT or diaspora organisations are relevant, but these will generally carry less weight than other factors. Could we have the next slide, please? So then looking at the first of the 6 criteria, as it were, the nature of particular organisations, it's important to note that the tribunal considered that prescription, as Alistair has mentioned, will be a relatively significant but not determinative factor. They didn't rule out that a person might be active on their own rather than with a particular organisation, but the focus was on relevant Tamil diaspora organisations. The TGT was found to be avowedly separatist and born out of the LTT in the sense that its founder and Prime Minister, Rudra Kumaran, was a senior member of the LTT and legal advisor during the peace process. And the tribunal concluded that the TGT is deemed to be a front for the LTT. It was held that it's reasonably likely that the government of Sri Lanka have a significant adverse interest in other prescribed organisations, so those that are on the list of prescribed organisations, which is reflective of the government's view that they are involved in terrorism or financing terrorism. So in relation to the Global Tamil Forum specifically, which was one of the organisations re-prescribed in February 2021, they're an organisation that are considered with significant hostility and again considered to be an LTT front. In relation to the British Tamils Forum, again, an organisation re-prescribed in February 2021, the tribunal found them to be sympathetic to the separatist agenda, but not a front for the LTT, but still have a significant degree of hostility from the Sri Lankan government. Tamil Solidarity, which Alistair mentioned, was an organisation particularly RS and her husband were involved with, were not regarded as a front for the LTT, but there was hostility to the organisation because of its agenda, namely that they were separatist and have a highly critical record of Sri Lankan's human rights record. The tribunal, of course, dealt with a number of organisations, and the determination deals with some others than we've addressed in this slide. But they noted that in respect of an organisation that isn't addressed within the guidance in KK&RS, it will be for individuals concerned to adduce evidence of the organisation's agenda and activities. So it's not being prescripting or limiting the organisations that may be relevant to those described in the judgment, but just important to go back to the aims, objectives and activities of the organisation. Could we have the next slide? So the next factor, the second on the list, types of activities. The upper tribunal noted that GJ made specific reference to attendance at demonstrations only, but considered that there was reliable evidence of a greater range of diaspora activities that were relevant to the overall risk profile, and concluded that this was included, but not limited to, the activities that we see here. So attendance at public demonstrations, attendance at meetings that may or may not be open to members of the public, actual membership of or particular roles in relevant organizations, distribution of promotional literature, meaningful fundraising on behalf of or providing meaningful fundraising to relevant organizations. And what is meant and is defined as meaningful fundraising is fundraising that's reasonably likely to come to the attention of the authorities and likely to incite interest. One example the tribunal uses is Tamil Elam National Card, where they said that, of course, someone pays money to get a card, but you don't have to be a member of the TGT, for example. So that's unlikely to be meaningful fundraising. Then attendance at commemorative events such as Heroes Day, Mulai Vaikal, Black July, authorship of or appearance in articles, so either print or online, and social media activity, so either posting or promoting the views of others. So if you have someone writing their own posts or sharing the posts of the TGT, that kind of activity. Then political lobbying on behalf of an organization, and signing petitions perceived critical of the government of Sri Lanka. So a broadening, appropriately, of the types of activities that the tribunal should be looking at when conducting this indicator-based assessment of risk. Could we have the next slide? So next we're going to move on to look at monitoring and information gathering in the UK. And the tribunal notes in the head notes, but then further detail throughout the determination, that the government of Sri Lanka continues to operate an extensive intelligence gathering regime, both in the UK and in Sri Lanka, but focusing on the UK, utilising information acquired through infiltration of diaspora organisations, as in GJ, photographing and videoing of demonstrations, and monitoring of the internet and unencrypted social media. The tribunal found that it's reasonably likely that the government of Sri Lanka will want to gather more rather than less information on organisations where there's adverse interest and the individuals connected on them, essentially casting the information web broadly, and noted that there's been greater capacity in terms of technological capacity since GJ, keeping a pace, in a sense, with developments in communication technology. The tribunal felt that there was insufficient evidence of capabilities to access the organisation's database, so lists of members and supporters, for example, of a relevant organisation, but noted that given the variety of methods available, it doesn't prevent the authorities from being able to access relevant information on individuals. The tribunal considered that there isn't evidence yet of an ability to access encrypted social media, such as WhatsApp or Signal, but generally looking to gather as much information as possible. So then looking at interviews at the Sri Lankan High Commission, this of course was addressed in GJ and it was accepted by the parties and found by the tribunal to be a process that continues, but only for those returning on a temporary travel document. And the tribunal considered that they would be very surprised if questions on surplus activities were not standard practice at the Sri Lankan High Commission, noting that it's a prime opportunity to ask a member of the diaspora about their activities and their views. Looking at what was said in GJ, which was about questions about LTT connections and sympathies, the tribunal thought the primary focus would be on diaspora organisations known to have a separatist agenda rather than the LTT itself. Could we go to the next slide, please? So those returning on their own passport will not be interviewed in the UK. That's not controversial, but the tribunal noted that that doesn't discount the Sri Lankan government's ability to obtain information on the relevant factors through its information gathering regime. The tribunal then looked at in detail kind of what happens to information when it's gathered, and said that the starting point for processing information is the defence attaché at the Sri Lankan High Commission. who applies a basic filtration to the information. And when making this finding, the tribunal considered and placed weight on the job description of Brigadier Fernando. They thought that it was reasonably likely that the defense attaché's filtration will not be rigorous. And the attaché will then pass information on to specific recipients in Sri Lanka, including the Army, State Intelligence Service, TID, CID, Ministries of Defence, Internal Affairs and External Affairs. That's all in paragraph 421 of the judgment. So essentially a broad range of the key organisations involved in the security apparatus in Sri Lanka. It considered that the passing of information strong part on purely factual information. Sorry, my apologies, my screen's just frozen. So purely factual information on surplus activities, so the kind of what, the when, and on whose behalf in terms of activities in the UK, and also in part on the government's perception of what that amounts to. So GJ didn't consider in any great detail the issue of databases, so the kind of practicality of the databases held by the Sri Lankan government. But in KKNRS, they held that it was reasonably likely to be a single comprehensive database, although other agencies may have their own, but a kind of single source of information, and that it will contain information passed back from the UK, so surplus activities, and also information from Sri Lanka, so known and suspected LTT personal or family connections and history of detention. They also considered that the long-term preservation of data is highly likely, and the government is unlikely to delete information once it's placed into the institutional memory. Could we have the next slide, please? So concluding on the information that the government is likely to obtain before a person returns on a TTD, we have it there. So essentially association with organisations and the other factors that have been identified under the assessment, the significant role assessment. One point that's of interest potentially is looking at the nature of involvement and the display of LTT emblems and banners at events was considered to be relevant. So if we could go to the next slide, please. Looking then at the stage at return, so when someone is back at the airport, the tribunal found that following its analysis, there are essentially 4 separate categories. So those of whom nothing material is known and therefore no entry on the database. Secondly, those people where there is an entry on the database, but they're not either on the stop or watch list. Thirdly, those on the stop list, and fourthly, those on the watch list. The tribunal upholds that the stop list still exists and constitutes those against whom there's an arrest warrant or court order. And it was uncontroversial. The tribunal said that those on a temporary travel document will be questioned on arrival. Those who are on a stop or watch list, so those on a stop list will be detained and taken away from the airport. And those who are on their own passport, similarly, if they're on the stop or the watch list, will also be questioned. As I say, reaffirmed that those on the stop list will be detained immediately. And at that stage, the tribunal notes, risk of persecution, serious harm materialises. For those on the watch list is where there's a further consideration of the breakdown or the analysis that the tribunal and the Home Office should follow, essentially reaffirming GJ that such individuals won't be detained, but will be permitted to return to their home area. And the tribunal found that within the watch list category, there are 2 subcategories. So those who, because of their existing profile, are deemed to be sufficiently strong adverse interest to warrant detention, and those who are of interest but not of a level to justify detention at that point in time. The tribunal held kind of subcategory 1, so those deemed of sufficient adverse interest to warrant detention are not just therefore at risk of being watched or monitored, they are at risk of detention and therefore persecution. The Secretary of State made a submission in relation to this category of the watch list that those in the first subcategory would in fact only be at risk if they were involved in further relevant activities. The tribunal rejected that, saying, if someone is of interest, that is the end of it. They have a well-founded fear of persecution, and said the Secretary of State's position was in effect requiring someone to show a risk of persecution twice. If you could go to the next slide, please. So just looking at the situation following return, the tribunal said that those who have a significant role will be detained after return to their home area, and others will be monitored. They consider that there's limited political space for pro-Tamil political discourse in Sri Lanka generally, and no tolerance in Sri Lanka for avowedly separatist or perceived separatist belief. They consider that monitoring will involve local catchers and also undercover security staff, and also that the authorities can monitor electronic communications, so internet, social media, Facebook, etc. In general, the tribunal found that, as in GJ, monitoring is not persecution. But in exceptional cases noted, for example, if you have someone with severe mental health problems and the process of monitoring will have such a detrimental impact, it could permit them to succeed under the convention and also Article 3. The tribunal also noted there's a need to consider HJRN principles when addressing post-return monitoring in terms of the activities that someone may wish to do and be prevented from doing. Just finally, the tribunal considered that rehabilitation is no longer reasonably likely, and as I think Alistair alluded to earlier, that it's unlikely that a returnee would be recruited as an informant. Just didn't consider there was sufficient evidence to come to that conclusion. I'm conscious of the time. I think probably we should move to questions now, maybe just as a final 30 seconds, just to consider that the HJRN principle, and the tribunal noted that it's critically important beyond the country guidance for tribunal to have regard to wider principles of refugee law. Of course, that must be right. But often, I think first-tier tribunal judges feeling constrained by the country guidance don't go beyond it. But HJRN, the tribunal says, must be considered in every case. But it's, of course, particularly relevant in claims where a person is, for example, not on the watch list, but not someone of a significant role, or for those who against whom the regime will have no record. So those kinds of cases that weaker evidentially is probably where the principle will have more prominence. And the tribunal says it's necessary to look at what an individual will do, or at least will want to do, in terms of expression of their genuine belief in the establishment of Tamil Eelam, and guides the tribunal, guides in the judgment through a staged process of looking at the assessment of the genuineness of belief, and whether an individual will be prevented from expressing their belief for fear of persecution. But they strongly found that any separatist activity in Sri Lanka is incredibly dangerous, and noted that the authorities in the north and east would be reasonably likely to become aware of pro-separatist activities or open expression of such belief. So in short, if somebody would express their views publicly on return, they will be a refugee. There is a well-founded fear of persecution. And if they wouldn't, then it would be similar to the HJRN principle, it would be an infringement or kind of inappropriate constraint on their political view if they were to avoid expression of it for fear of persecution, and similarly they succeed. The tribunal rejected the Secretary of State's submission, essentially that if someone was committed to Tamil separatism, they could support federalism as an alternative, stating that that was wrong in principle, as if a person holds a particular set of political beliefs, they can't make do, in a sense, with another political view to avoid persecution. And finally, on this point, the tribunal noted there isn't a need to show equivalence of activities in Sri Lanka, so you don't need to demonstrate you would want to be involved in the same types of activities that you have in the UK, of course, because there isn't the space for it, or the organisations, or the demonstration, or lobbying, etc. So just a useful additional point to consider, as I say, in all cases, but particularly those that don't meet the other criteria. So sorry, I realise I'm slightly over time. I hope that's helpful, and we'll now go to questions.
Right, thank you very much, Antonia. I've got a question which raises a few quite specific, case-specific points, which I'm afraid we can't really answer questions about people's individual cases in this seminar. I hope you'll understand that. But Aaron, would you like to say a little bit about what sort of evidence might be generally helpful in somebody's asylum claim or fresh claim, obviously without sort of specific reference to anybody's facts? And then Laura, perhaps you'd like to add to that.
I think definitely. I think a detailed witness statement would be very important. I think the witness statement can cover the factors Antonia very helpfully set out in her presentation. That would be helpful. I mean, for an example, setting out the nature of the political activities that you have undertaken, types of activities, extent of your involvement, duration of your involvement, and your individual history, and your familial connections, and if any facts have been accepted in you said you're submitting a fresh claim. So if any facts have been accepted in the previous claim in the appeal, if you can include that as well, that'd be helpful. That's all I can think of.
Thank you. Laura, would you like to add to that? And I think you also wanted to say something about the documents considered in the case, including the CPIN and the fact-finding mission. Unmute yourself, yeah.
Yeah, not too much I can add to that. The tribunal did say that TGT membership card isn't going to get you very far. So yeah, I think the statement is really helpful, obviously. The letter from the TGT minister, the more detail they can give specific to you, the more persuasive that will be, but it's certainly really helpful. And same with the photos, if they can be sort of have descriptions, talk about if you played any particular role, the tribunal highlight that as particularly important. And then, yeah, just to mention one other hopefully useful element of the guidance was some of the treatment of the Home Office's policy and fact-finding mission. So in relation to the CPIN, as should be clear, but you know, the tribunal emphasised that it is merely a restatement of the Home Office's policy. So it is not country evidence in itself. The evidence it cites, of course, may have evidential value, but that was where it refers to the high profile and prominent membership, which is discredited. And that comes from the fact-finding mission, which is quite strongly criticised for its methodology. And I think in particular, one thing that stood out to me was the presentation of the report begins with two very lengthy summaries of the evidence, and then the interview records are put as an annex, but the judgment makes clear that it's only that annex which has any value. And when you think about the value that can be attached to that annex, you have to think about the fact that you don't know too much about those sources, that those sources don't cover the whole spectrum of Sri Lankan society at all. In fact, there was only one Tamil source in this FFM on Tamil separatism, and maybe a half or third were government sources in some sense. And then when you look at the summaries compared to that, and then you look at the CPIN compared to that, they were not accurate either. So there's Asylum Research Centre reports, which are really helpful at showing all the problems in those. But I believe the CPIN's already been taken down. The FFM is still there. The DFAT reports, which inform the CPIN and also CPINs for other countries, were also criticised for methodology, as was also the evidence from the Sri Lankan High Commission, where they said, now that groups have been deprescribed, we think it's, you know, totally fine for members of that group or something, you know, and they say actually it's a much more nuanced assessment than that.
Thank you. Yes, I mean, the criticism of the DFAT report, which is an Australian government report, has caused some excitement, I think, in Australia amongst people agitating for the rights of Tamil refugees there, which is obviously a very positive thing. Just a couple of other points to add to what Aaron and Laura have said about that. Definitely an issue arises about how case-specific some of the letters that one sees from political parties or political movements are, and obviously the more specific they are about the individual's activities rather than about, what they would like to say about the situation in Sri Lanka, the better. The tribunal has decided what it thinks about the situation in Sri Lanka. That it's not going to be sort of shaken from that view by more representations from a Sri Lankan politician. What it will be interested in is evidence from that person of the individual applicants' activities in the UK or wherever it might be. And the other thing, which I think nobody has mentioned, although correct me if I'm wrong, is what can be helpful sometimes is statements from friends and colleagues who are in the movement. So, people who say, yes, I'm a cousin or I'm a friend of the applicant, and yes, I've seen them at loads of demonstrations. I go along with them every time. I often see them leaving the house, with placards and this sort of thing. That can sort of add a lot of colour to it, actually, and can be quite hard evidence, actually, sometimes for the Home Office to counter. So that kind of thing can be very helpful. Antonia, did you want to add anything to that?
No, I think that covers everything. I mean, just maybe looking at the social media and kind of Facebook type posts, looking at the TGT's Facebook and where information is gathered, kind of looking in the light of what the tribunal said about consideration of social media, things in the public domain, articles, just again, looking back at that type of material to see what can be found. But otherwise, I think everything's been covered.
Okay, we've also got a question here from Janani asking about links between findings in this case in the ECHR, European Convention on Human Rights. Hopefully broadens the law in the UK. Germany, however, are deporting all the Tamils they can. And is there something applicable to this across the continent? Aaron, is there anything you'd like to say about that?
I think it's about the general use of the country guidance. So I think Alastair and Antonia can talk about how far the European Court of Human Rights might, based on this case, take the approach. I don't know how they will approach Tamil cases. NA versus UK was the last big case that I'm aware of. But country guidance cases play an important role in other jurisdictions as well. So, for an example, it impacts Australian approach to Sri Lankan asylum claims, and even France in the past, they relied on the Home Office guidance that was based on GJ or on GJ directly. So I'm sure based on KKNRS, other European countries also might change their guidance or take into consideration what the KKNRS says. But I don't know whether it will play any direct role in decision making in other European countries like Germany.
Yeah, I mean, the situation in Germany is quite concerning. I think there have been, as the question said, a lot of detentions and attempts at removal. I don't know if there have been any successful removals. Obviously, that is quite concerning, particularly in the middle of a pandemic. But countries do look at each other's case law and at each other's reports, and there's sometimes a slightly unhelpful sort of recycling of reports. So the Australian reports rely on the Home Office reports, the Home Office reports rely on the Australian reports, etc., etc. So it may very well be that this judgment will cut through a little bit and stop, governments relying on each other's assessments to back each other up. And as Aaron has said, the European Court of Human Rights has certainly paid a lot of respect to UK country guidance cases, and it may very well be that it will do so with this one as well. It's obviously an extremely detailed and lengthy judgment, which I think it's fair to say most people reading will find extremely impressive, although not necessarily the Secretary of State, who I should say has sought permission to appeal in both cases. Obviously, we'll keep everybody posted on that. We've got a little bit more time if anybody's got any more questions. Stick them in the chat as soon as possible if you can, please. Otherwise, I'm going to give you a countdown of 3, 2, 1, and then I think we'll close. So thank you very much for participating. Thank you very much to Antonia, Aaron, and Laura. as I say, watch the space, because there will be there has been an application for permission to appeal. And we'll try and keep you all posted, and keep an eye on the tribunal website, as I'm sure any successful application for permission will be posted next to the judgment as it appears on the tribunal website. But for today, thank you very much to everybody, and we'll see you all again soon. Thank you. Bye.